Okay, everybody, now we've kind of covered the inspections. We've covered the proration of fees. Let's talk about item 12 here, federal fair housing compliance and disclosures. I can't tell you how many times I've seen agents not know what this is. Well, if you noticed at the beginning of the purchase contract, we had the federal fair housing logo there. If you're a licensed real estate professional, you need to make sure you abide by each and every one of those laws. And as you can see, you cannot discriminate. And when we say discriminate, all properties are offered without regard to race, color, religion, sex, national origin, age, gender identity, or expression, familial status. Okay? You need to make sure that you watch those. Now, the biggest thing that I see, guys, in this particular situation, unfortunately, it does come up. Maybe a seller says, I don't want to sell to this person for whatever reason it is. You have to advise that client that that is not allowed and that they need to abide by that or they can get in some very deep trouble. Next item we have, item 5, item 13, walkthrough inspection of the property. Buyer is entitled under this agreement to walkthrough of the property within X amount of calendar days prior to the close of escrow. You're probably asking, well, why are we going to walk the property? We've already done a home inspection. Good question. So, lesson for you here. First year of real estate again for me. That was a great first year. I learned a lot of lessons, and you will learn a lot of lessons yourself in that first year as well. So, we go over to the property to do our final walkthrough 3 days before we close escrow, right? Well, when we did the home inspection was great, few items, nothing major. But in the living room, there's a big sofa with a huge area rug in this wood floor. Generally, best practices is when you go to do a final walkthrough, if possible, the home should hopefully be vacant. So anything that's blocking the walls, shelving units, flooring, now we can see if there's anything that's, different about the property, if you will. The additional bonus to doing the walkthrough, if you will, is if there were any agreed upon repairs from that inspection, we can ensure that those repairs have been made and up to the standard prior to signing our documents and taking ownership of that property. So, back to my example. We show up to do the final walkthrough. Unfortunately, the sellers weren't completely out of the home. Pretty much, but not completely. Well, in that living room, there's that big, beautiful sofa with the area rug. So we do our walkthrough, my buyer's fine, everything is great. We sign off, we proceed to move forward to close escrow on that transaction. Next day, I'm excited, I'm giving my buyer his new keys, and I meet him at the home. Here's your new house. We open the door. Sofa's gone, big area's rug's gone. That's a relief. Oh, there's a big hole in the ground. Now, when I say hole, I'm not talking about a hole I'm looking into, but there was about a 6x4 area of that wood flooring that was missing, which the area rug was covering. Now, did it go back on? Deceptive possibly for that seller? Absolutely. Is it worth the time and energy for that buyer to do so? Possibly. However, in this particular scenario, my buyer really wanted the house, said, you know what, Dave, you've done a great job. We didn't see this. I'm going to tear this flooring out anyway and put some new stuff in, so don't worry about it. Whew. Boy, was I relieved because I didn't know what I was going to do. First time agent, I was shaking in my shoes. So at all possible, when you do that final walkthrough, guys, make sure that that home is vacant so that we can see every nook and cranny, if you will, or make sure any repairs that we were looking for have been completed. Line 18, number 14, delivery of possession. Now, you'll see here it talks about once everything has been met, all terms of the contract, is it going to be at close of escrow or is there a different date? Now, I know you're going, well, if we close escrow, Don't we get possession of the home? Most cases, yes, you do. However, if you remember, we're talking about timelines and negotiation. Maybe for some specific reason, that seller needs to stay in the home beyond close of escrow, and they're going to become a tenant, if you will, for a few days. So if that's an applicable situation, as opposed to our close of escrow date, maybe it's 5 days after the close of escrow. Again, that's going to be specific to each and every contract, whether that is applicable or not. Next item, 25, line 15. I've got another great example for this one. So basically on risk of loss, guys, we go to do that final walkthrough, or at any time in that transactional period, something happens to that home that can impact the material value of it. Property got flooded, water line busted, fire, something that has changed the value of that home. That basically states under Nevada revised statute that the buyer at that point in time can back out of that contract without any damages, if you will, or default in the contract. So my example is this. We show up for that fabulous final walkthrough. As I pull up to the house prior to my buyer getting there, the house next door to my client's home that he's purchasing had burned to the ground. The home literally was just a pile of rubble. So at first I'm like, wow, this is pretty crazy. As we started to do our walkthrough, we had noticed from where the house had burned down and my client's property was, the heat had got so intense that it had literally melted all of the roofing fascia and siding. At that point in time, my client could have exercised risk of loss. However, getting back to being a good negotiator, I asked my client, I said, Mr. Buyer, if this wasn't here, would you still want to buy the home? He says, absolutely. I said, well, let's explore this a little bit more. So with the cooperation of the seller and the seller's homeowner's insurance, the adjuster came out and said, hey, we can actually fix this, make it better than new, or better than what it was when you were buying it. My buyer agreed. We signed a 30-day extension to close escrow. Homeowner's insurance came out, repaired the roof, better than before. We proceeded to close escrow. My client got their new home. However, he could have exercised his right under risk of loss. Line 30, number 16, assignment of this agreement. Unless otherwise agreed in this contract, you cannot assign this contract. What does that mean? Mr. Jones offered to buy the home, and unless there's something in the contract agreed upon by both parties, Mr. Jones has to buy the home. I can't transfer it to a friend or my daughter or whomever during that process unless, again, agreed upon. And you will also find that most banks or lenders, if you're taking out a loan, will not allow that. Next item, line 33, number 17. Cancellation of this agreement. As long as we cancel that, well, let me rephrase that. If we choose to cancel it, as long as it's within any of the contingencies or timelines established in that contract, we have the right to do so. However, if we decide to cancel just for no good reason, your buyer could subject themselves to legal ramifications. Default. Mediation. Mediation is offered through most associations or your state. That's where both parties come to a mediator and try to work out whatever differences may be holding up this transaction or if there's an earnest money dispute. By agreeing to mediation, you're not waiving your right to pursue through the legal channels, but it's generally a good first course of action if we can come to a mediation and come to an agreement without having to incur additional fees and charges by going through a legal process. 48, line B. If a seller defaults in performance under this agreement, buyer reserves all legal and equitable rights to pursue that seller if they wish to do so. Item C, if the buyer defaults. Now, we get back to If the buyer defaults under this contract, we will have liquidated damages. We have a $3,000 earnest money deposit, and with liquidated damages, the seller says, hey, if you back out or you breach on this contract for no good reason, I will keep that $3,000 as liquidated damages and won't pursue you for anything else. Again, it's very important for you as an agent to understand the mediation, cancellation, those type of things in the contract so that you can advise your client accordingly. All right, so next we're going to talk about escrow. Escrow is the period we're managing that transaction, right? And essentially what I like to say, guys, the title escrow company, the real estate attorney, generally are going to be a disinterested third party, right? They're just there to make sure that we do what's required by law to transfer ownership from one entity to the other. Next item we're going to talk about, line 20, unclaimed funds. Now this can vary from state to state from wherever you're at, but in the event funds from this transaction remain in an account held by the escrow holder for such a period of time that they are deemed abandoned, okay, and this in Nevada law, chapter 120 of the Nevada Code of Revised Statutes, basically, guys, in a nutshell, what that's basically saying, I'm not going to go through the verbiage on that technically. You've got it in front of you. You can read it. If your buyer or seller has money coming back at the end of that transaction, you need to make sure that they know about it and that they're getting that money back. Plain and simple. Broker's compensation and fees. You've done all this hard work to manage the transaction, get your client the home. It's time for you to get paid. Generally speaking, okay? Those are negotiable. Who's paying for what as far as agent, brokers, commissions are concerned. Traditionally, the seller is generally responsible for the broker's fees and commissions in a transaction. However, that is not always the case. But you will also see additional terms in this. Sellers or buyers will pay an additional fee and compensation, maybe above and beyond. If that is the case, you want to make sure you have this correctly marked. But the biggest mistake I see, guys, is that they don't disclose that to their buyer. Oh, well, what is this fee? So as we progress down to the end of the contract, you'll see a spot in there that talks about where those are going to go. Waiver of claims. What does waiver of claims mean? Again, you've got the contract in front of you, but you'll want to take a look at that. Meaning this, a lot of the information we provide to our clients are through public records. These homes sold for this amount. That's how we came to the value, right? Properties, X amount of square footage that we took from the county tax record. X amount of bedrooms. One of the biggest things I see in real estate is, oh, it's a 4-bedroom, 2.5 bath. And then you show up to the home and there's really only 3 bedrooms. And then there's this little room that there's no closet, there's no window. Technically, that's not a bedroom. We are only providing the information through public record, and we want to make sure that we're conveying that to them. So they're saying waiver of claims. We're providing you this information based on public record, and you're not going to hold that against me. Make sense? Very good. All right. So guys, now we're getting actually towards the end of this purchase contract. Definitions, right? You do this every day. So a lot of these definitions and or acronyms are kind of second language to you. Again, never assume that your client knows what you're talking about. So I always like to breeze through these a little bit to kind of help educate them, right? We're talking about COE, close of escrow, CIC, community interest, common interest community, or HOA, homeowners association. So basically we've got just kind of the terminology, if you will, of what the contract talks about. Signatures, delivery, and notices. 26, item 24. This agreement must be signed by the parties on more than one copy when taken together. Each signed copy shall read as the complete document. Okay, basically, guys, I'm going to go through 24, A, B, and C, or A and B here, rather. Okay, we need to have signatures by both parties so that we can ratify the agreement. If there's any changes, right, it needs to be signed by both parties. Delivery. If I write an offer that says your seller needs to respond by X amount of days, we need to uphold that. Or if we're going to act within a time period of contingencies, we need to do that. IRC 1031 exchanges. Now, that'll be another class. However, if a seller is participating in a IRS 1031 tax exchange, that's essentially where they're selling one property, they can't touch any of it, and moving it to another property. Most reasons why sellers will do that is to avoid any capital gains on that property. Other essential terms. Time is of the essence, right? We need to act within the body of the contract and the timelines established. No changes or modifications are made to that contract without both parties signing, okay? Make sure that we're always managing the contract to the best of your ability, managing those time frames. This is a legal and binding contract. Now, one other thing, guys, I want to point out as we're scrolling through this, you'll notice at the bottom of each page, we have the buyer's name, the property address, spot for buyer and seller's initials. That's going to be on each one of those. And we want to ensure, as we're getting that contract back, that each line has that initial on it and or signatures where applicable. This form here has been approved by the Greater Las Vegas Association of Realtors. Addendums attached. So we're going to jump to number 12, 27, 28. Are there any additional addendums attached? When you say addendums, we haven't even negotiated the deal yet. Well, remember we talked about, does the buyer need to sell a property to buy the new one? There's an addendum for that. Is it a short sell? And again, that's for another class, but a short sell essentially is the seller needs to sell the home, but they owe more than what it's worth. Any additional addendums that may be applicable, you're going to note that here, contingent to sell property addendum. Are there any additional terms? On the additional terms, guys, what we want to talk about there are, well, let's see. Remember where that transaction, were there any additional fees to be paid? I always encourage you to include that here. Buyer allows seller to lease back property for 5 days after close of escrow. Anything that's additional that's not already stated within the body of the contract, we want to make sure we talk about it right here. Confirmation of representation. Pretty self-explanatory there. Buyer's broker. Who's the broker? Now you might think, oh, well, I'm the broker. No, you're the real estate agent on this transaction. Whomever you're working for is the broker. The company name, license numbers, contact information. That's going to go for buyer in this particular part of the contract. Buyer's licensee disclosure of interest. What does that mean? Well, I'm representing buyer A, and buyer A is a family member. I have to disclose that. I'm going to buy the property with the buyer, and we hold it in a trust together. If there is any relationship, you have to disclose that to the other party. Remember, we talked about being fair, ethical. That's part of that process. Now, seller must respond by. That's where we put in the contract that the seller must respond by a specific date and or time. We've got a line down here, 44, for buyer signatures. Now, if we have multiple buyers, we got 2 spots here. If we need additional, we just add that in. Buyer's printed name, date, and time. Make sure you not only have the date, guys, but we have the time. I submitted the offer at 10:15 this morning, right? If I don't have a time, maybe if there's multiple offers, that creates a bit of a problem. So again, just make sure we're as thorough as possible. Again, buyer's name, property address, signature lines. Here we have the seller's response. Again, as you can see, the confirmation of whom is representing the seller. Is there any disclosure of interest with the seller? sorry, I jumped back on the slide there. Oh yeah, I'm selling the home, it's my aunt. Again, any relationship that needs to be disclosed needs to be disclosed. Acceptance. Now this part here from line 31 to 36, guys, talks about the seller's response. If they accept it, they're going to mark or initial there. If they're going to counteroffer us, or they reject it. Seller's going to sign, print, date, and time. Now, if we have a signed accepted offer, this is all we need. If there's a counteroffer, there'll be an additional document that the seller will provide back to the buyer for further negotiations. Or if they simply reject your offer, they need to provide that document showing that the seller's rejected your offer. That concludes the walkthrough of a residential purchase agreement. Hopefully in your real estate career, you'll have many opportunities to write these contracts and succeed for your buyers in securing those homes for them. Study the contract, know the contract, because it puts your client in the best position to win, but it also keeps you and your broker out of trouble. Thank you so much for joining me today. I look forward to seeing you in the future and wish you much success.